Welcome to Grow Money Business, the podcast dedicated to helping business owners optimize income, pay less in tax, and invest prudently. Here's your host, Grant Bledsoe.
Hello, everybody. Grant Bledsoe here. Welcome back to Grow Money Business. This week on the show, my guest is Lee Phillips. Lee is a U.S. Supreme Court counselor and federal tax court attorney and specializes in asset protection using business structures like LLCs and corporations. We had a great conversation in this episode. Lee is a curt and colorful guy. He dove into the genesis of LLCs in the U.S. and the legal principles where they originated in Europe back in the 1400s, how they apply today, and what we need to think about in terms of protecting our assets from liability and potentially even bankruptcy down the road. This was a conversation where I learned a whole lot. I think that the message that Lee sends is not something that you typically hear from your typical estate planning and asset protection attorneys, and it was one that I thoroughly enjoyed. I am confident that you will as well. Hey everyone, I need to interject quickly to remind you all that nothing found in today's episode or any other episode of Grow Money Business should be considered financial, investing, legal, tax, fitness, or even relationship advice. It's content that you're free to use and to deploy on your own terms. And before taking any actions on content found on the show, please do consult with your tax professional, your attorney, or your financial planner. If you don't have a financial planner, head on over to threeoakswealth.com to learn more about what we do in terms of financial planning and investments and how we help clients on an ongoing basis. Lee, thank you for being on with us today. Welcome to the show.
Well, thank you for having me. It's great to be here.
You've had quite a career, and you were just telling me a moment ago that you have surpassed 10,000 hours of live speaking, which is quite a feat that I am very impressed by. You must have been doing this for quite a while.
I've been doing it for a long time. I've got my 8 millionaire miles.
So tell us a little bit about your career, your background, and your work.
Well, I wasn't supposed to be a tax asset protection type lawyer. I'm supposed to be a patent attorney. And I graduated from law school, got the job in the big patent firm and worked for about 5 weeks and got sick, was diagnosed with cancer, given 2 to 3 weeks to live, spent a little over 6 months in intensive care and didn't work for 3 years. And my young family, my wife and 3 kids and I lost everything. And we had no debt. We had done everything perfect. So what we need to talk about is whether you're 27 years old or whether you're 67 years old, we need to think about protecting the assets that you have so that if something happens to you, you don't lose everything. And your common scenario, if I say asset protection, your knee-jerk reaction is lawsuit. No. 56% of all bankruptcies in the United States are a result of somebody getting sick. And yes, I have a cold. I've got a mask over the microphone, so you won't catch me, okay?
It should be okay.
You'll be fine. But 56% of all bankruptcies, somebody in the family gets sick. The question is your client going to lose their portfolio when somebody in the family gets sick? And the answer for most of your clients is yeah. Well, I lost everything and I said, this ain't going to happen to me again. So I started to study asset protection and stuff. And this is something that I didn't have any lawyers that could help me. Nobody did it back then at all. And we've got some that are doing it now. But back then, nobody did anything. And it was very difficult, actually, to put it together because the lawyers just use the form. They just do what the firm taught them how to do. And they can't tell you why, if you do this, this happens. And it was hard. It took me years to figure it out. And in fact, I'm still figuring it. But for example, as I've gone along, the issue comes up, what's your biggest asset protection threat? What is your biggest asset protection threat? It's the IRS. the IRS has taken 20, 30, 50% of everything you make? That's an asset protection threat. I actually wrote an article for the Physicians Money Digest for about 8 years. It's not even around anymore, but it was the biggest doctor magazine, financial doctor magazine, went out to 800,000 doctors every year or every month. And the doctors would get me on the phone and they'd say, hey, Lee, how do we get an extra percent, 0.5% return out of our money? That's a big deal. And my question back to them is, yeah, that's a big deal. How is it taxed? Because if I can control the taxes, I can control how much money you make. And I can give you a huge bump in your return if it's tax-free. Now, I don't mean to insult you, okay, Grant? But this is the way I say it. You can't find me a lot of people that have said, wow, my stockbroker made me rich. And I understand you're not a stockbroker, you're an investment advisor. Big difference there. But you can't find me anybody that says, wow, my stockbroker made me rich. You can find somebody that says, I made money in my IRA. Well, I got news for you guys. Your stockbroker is no smarter managing your IRA money than he is your standard stock portfolio. The difference is the taxes. The IRS advantage, the tax advantage of the IRA outran the stupidity of your broker. So how is your investment taxed? And as I've gone along, I started lawsuits, I started illness, I started all this stuff, and I'm gradually into taxes. I'm a federal tax court attorney now. And I've got a lot of former IRS agents in my office. So these are the things that we're talking about, Grant, and I don't know what in there interests you, and you can direct it anywhere you want, I guess.
That's great. I appreciate that background. First off, you're going to have to work really hard to offend me, to be totally candid. So,
this sounds
bring
like
the heat. We're going to be just fine.
he just threw down the gauntlet. I mean, he just threw it down.
I've been through the ringer in the past.
I'm a lawyer.
I think we'll be all right.
I'm a lawyer. My granddaughter went to school this fall, and the teacher says, well, what does your grandpa do? And she says, well, he's an attorney, a lawyer. And the teacher says, honest? And my granddaughter said, well, no, he's just a regular one.
Honest lawyer, right? Oxymoron, age old growth.
Don't exist.
Yeah, exactly. So just for a little bit of context, we talk a lot on the show about tax planning. We talk a lot about how and when to take money out of IRAs, conversions, all that stuff, capital gains versus dividends versus interest income out of a taxable account. We do go fairly in depth, I would say, from a tax perspective. Probably so than the average.
You've got to go in depth in a tax perspective. Have you ever seen the dollar double 20 times trick, Grant?
The dollar double, explain that for me.
Dollar double 20 times? $1,
you double it 20. Yeah, and it I don't know what the
$1, $2, $4, 8, 16,
Sure.
32, 64. You got it?
Yep.
You end up with $1,048,000 and change.
Mm-hmm.
Not bad, huh? Okay. Wait a minute. There's no tax on that double, is there? Everything you do is taxed. Let's tax it. Let's tax it at 40%. You get your Fed, your state, people are in a 40% tax bracket. So $1 becomes $2, but wait, I've got an extra dollar in profit. I got to tax it at 40%. So I don't end up with $2. I end up with $1.60, right? Double $1.60, that's $3.20. But I got to tax the extra $1.60. I don't actually get $3.20. I only get $2.56. So over here, I've got $1,048,000. Over here, I've taxed it at 40%. Basically, that means I've lost $400,000. $400,000 is a big deal to me, guys. If I can get this without a tax, that's a big deal. So I've got 600,000 over here, right? I don't think so. I don't think so. How much do I have over here? Do I have 200,000?
I'm going to guess
300?
350.
350. Would you like to go to 250?
Sure. Sure.
Would you like to go to 150?
Yeah, let's go.
Would you like to go down to 50?
Okay.
Would you like to go down to 25? Come on, Grant, you got to stop somewhere. Over here, I've got 1,048,000, and I just imposed a 40% tax over there. That's all I did.
Sure. Now,
You
just
have
to push back on this a little bit,
okay.
realistically, yes, 40% tax bracket if you're paying short-term gains and realizing it every single year.
Well, I'm taxing it at 40%.
No, most people should not be doing that. But yes,
Well,
40% every time it doubles, sure.
you have 12,089. 12,000. You've got 1,048,000 over here. What people don't understand, what's the eighth wonder of the world?
Compound interest.
What people don't understand is taxes are literally compound interest in reverse.
Right. Yep.
And it's huge. If Grant can save you 10% on your taxes, that's not $100 out of 1,000. That's millions of dollars over your lifetime, guys. It's huge. So, the IRS is a big asset protection threat. And Grant and I, we were talking earlier, if you've got a big portfolio, you probably ought to keep it in an LLC for asset protection purposes. Now, wait a minute. You say, I don't need asset protection from my portfolio. I mean, how often have you had a client get sued because they invested in a stock or an annuity or whatever it is? Never.
Never.
You might lose your money, but you're never going to get sued. So why do I need asset protection? Well, we're not protecting you. The corporation protects you from what happens out in the company. What we need to do, and what the lawyers have never talked to you about, is how to protect the assets in the company from what happens to you. If I get sick, am I going to lose my portfolio? And the answer is yes. If I hit a kid in the crosswalk on the way to church, that's not a business problem. It's a personal problem. Am I going to lose my portfolio when I get sued? The answer is yes. So how do we protect the portfolio from what happens to you? That's the problem. I don't care. You're not going to get sued because you invested with your financial advisor. You might lose your money, but you're not going to get sued. So how do we protect this nest egg? This is my value. This is my retirement. Now, I'm not talking 401ks and SAPs and SEEPs and SAPs and all of those other things. Those are what are called ERISA plans, Employee Retirement Income Security Act, ERISA. Those by law are 100% protected. There basically isn't a judge in the United States that can take your 401k away from you. Now, you have to split it up when you get divorced. That's bad business. But if you get sued by hitting the kid in the crosswalk, nobody can take that 401k away from you. That's protected under ERISA. And just as a little sideline here, as long as we're talking asset protection, your IRA is not an ERISA plan. Your IRA is a trust under Section 408 of the IRS code. And by the way, if you ever want to know if your investment advisor dude knows anything about what he's doing, walk in and say, I want a 408 trust. And if he looks at you and goes, dude, you'd better get a new investment advisor, because a 408 trust is an IRA. And if they understand IRAs, that's a big deal. So they're not protected under ERISA. Many states have protected them. California is actually the worst state. They haven't protected them to speak of. But many states have protected IRAs. They're protected under the Rossi case in federal bankruptcy.
And when you mean protected from liability like your ERISA plans are.
So if I declare bankruptcy, the federal tax or the federal bankruptcy court cannot take away my IRA.
Right.
So they're protected. That's what I mean, protected.
Gotcha.
So the benefit plans, the HSAs, the HRAs, the flex cafeteria 125s, all of these benefit plans and all of the retirement plans, your profit sharing plans, your SEPs, your 401ks, your solos, all of that crap. That's all under ERISA, and that's 100% protected. So that's a great asset protection tool. So I've got my HRA set up. I'm never going to get rid of it, even if there's money in it after I retire, because it's protected 100%. You don't cash out your 401k. One, there's the tax problem, and two, it's protected. So you don't want to ever get money out of those if you don't have to. They're protected.
Right.
But if I just have my standard portfolio, it's not a retirement plan. How do I protect it? Well, what you're going to do is you're going to use an LLC, a limited liability company. A corporation protects you from what happens in the company. The LLC has that exact same limited liability. They call it the corporate shield. Protects you from what happens in the company. Well, if the only asset in the company is my portfolio, I ain't getting sued. The LLC has another aspect to it, which attorneys never talk about. And I have to give you a history lesson. Is that okay, Grant?
That's okay. I love history.
400 years ago in England, the only type of business structure there was a partnership. So me and Grant and Joe, we go into business together and we spend 30 years and we build a beautiful business. Joe gets in trouble. He hits somebody with his horse. He doesn't pay the king. He gets divorced. Joe gets in trouble personally. He gets sued. The guy suing him is called his creditor. So his creditor gets a judgment against Joe. And his creditor comes in and takes Joe's partnership. By law, Joe's creditor is now our partner, mine and Grant's. That guy can come in and do whatever he wants with our partnership. He can sell it. He can do whatever he wants with it. And Grant and I have no say in what happens. That ain't fair. Wait a minute. Grant and I worked 30 years. Joe screwed up and we lost everything? That's not fair. And the Brits said, yeah, that's not fair. So they passed a law which said when Joe's creditor gets a judgment against him, the creditor has to go back to court and ask for an order which charges his debt against our partnership. That guy can't be our partner, but if our partnership declares a profit, the creditor gets it. Joe doesn't get it anymore. We say that Joe's creditor has an economic lien against our partnership. Now, Grant and I, we kind of liked Joe. We ain't going to ever declare a profit. In fact, we can still hire Joe and he can work for us. So the charging order is what they call it, protects me and Grant. So when the LLC was created in the U.S., it was created in 1977 in Wyoming. Basically what they did is they married a partnership and a corporation. They got the corporate shield, the DNA from the daddy corporation. They got the charging order protection, DNA, from the mommy partnership. So the LLC now has both of these asset protections. which no other entity has. And so if I put my portfolio into an LLC, then when I get sued personally, I declare personal bankruptcy. They still can't get that portfolio.
Interesting.
They have to go get a charging order and ask, and the charging order is the economic lien against the portfolio. If the LLC ever declares a profit, now the portfolio could have a profit, we hope it does, but if the company, the LLC, ever declares a profit, this creditor gets it, I don't get it anymore. So that's why I say that you really, if it's a big portfolio, and I'm going to say a couple of $100,000, it's probably worth the expense of setting up the LLC and making Grant change from my name or my trust's name to the LLC's name. Why would I want my portfolio in a trust's name?
Probate avoidance.
It avoids probate. The LLC doesn't avoid probate. So how do I make it so that when I die, my kids still get the portfolio in the LLC without probate? It's easy. I make the trust the member, the owner, the stockholder of the LLC. Now I don't have to probate the LLC when dad dies. The LLC carries on, but the trust allows us to get a new member, manager, do everything, and we can still control this just like dad was alive. So it works very well, but we're putting this extra step in the middle. And that extra step, guys, is a big deal because I've seen a lot more people lose their nest egg because of something that happens personally. I was giving a 2-day seminar event and explaining all of this, and there's this 50-something-year-old guy. He starts crying, sobbing like a baby. And I'm going, okay, what did I say? And he had 6 pieces of property down in Las Vegas, 2008, 9, 10. He'd paid $700,000-$800,000 for each one of those pieces of property. In 2010, that piece of property wasn't worth $700,000. It was worth $150,000. He couldn't begin to rent it and make payment on his $700,000 loan, and he was going to declare bankruptcy. His bankruptcy attorneys had told him, okay, you're going to lose these 6 pieces of property. You're going to lose your house. You're going to lose about $500,000 in portfolio. You're going to lose another piece of property that you got that's a good piece of property. You're going to lose it all. And the short story is, by the time I got through with him, he lost about $50,000 and the 6 pieces of property. So we can protect the assets. You have to do it before you declare bankruptcy. In fact, there's a 5-year look back on bankruptcy. So do it now, then we've got it done. In this case, we had to work around things. For example, in Nevada, I can take $60,000 the day before I go to bankruptcy court and put it into a life insurance policy. That's protected. So I set up a life insurance policy for him and a life insurance policy for his wife. That's $120,000, right? We did this in November. Guess what we did in January? Another $120,000. Can you see how we're working on it?
Mm-hmm.
So we can do things, but you need to think of this now. And it might be the real estate market goes bad. It might be you hit somebody in the crosswalk on the way to church. It might be somebody gets sick. It isn't just the loss. There are lots of different things that threaten this portfolio that Grant's managing. How are you going to protect it? It's worth protecting. That's your major value right there, your home and this portfolio. So it's worth the extra steps to make sure that it is protected, and we can do that.
Why an LLC instead of a corporation? Why not organize an S corporation?
Well, a couple of reasons. One, the corporation does not, never has, will not have the charging order protection. Any other questions?
Nope, that does it.
That's it right there, sweetheart.
That's it.
Any other questions? The other reason is taxes. Do you really want your portfolio taxed under Subchapter S? Because in a Subchapter S, now I could have an LLC taxed under Subchapter S, or I can have a corporation taxed under Subchapter S. The LLC is the legal structure. The corporation is the legal structure. The Subchapter S filing is the tax structure. The tax structures and the legal structures have nothing to do with each other. Not a damn thing. The IRS doesn't know whether you've got an LLC or a corporation, and they don't care. So how are you going to have it taxed? If it's taxed under Subchapter S, then you get the money into the Subchapter S. By law, you have to take out a reasonable salary. That's subject to the 15.3% employment tax crap. So you've lost 15.3% of it on that. The rest of it you can distribute. That's not subject to the employment tax. So your portfolio income, it's not passive income like your real estate rents and your royalties, that sort of stuff. It's called portfolio income. Your portfolio income is taxed under standard procedures. Now you're going to make it so it's taxed as capital gains, but that's still not passive income. I would have it taxed as a partnership probably. Because you're not selling goods and services. You're not in a position where you have to take a salary out of it.
Right.
So you're going to have a partnership taxed under Subchapter S. Taxed as a partnership. That means you need more than one person to own your LLC. You got to have a partner. That could be your spouse in states that are not community property states, or we can put a kid on for 5% or something. And by the way, you should have at least two people, a partner, in your LLC. There are about 15 states now. The first one was Albright in Denver, and then we had Olmsted in Florida. Mr. Olmsted is a dirty dude. He embezzles tens of millions of dollars from Floridians, and the government comes and gets him, and they put him in jail. Mr. Olmsted has put these tens of millions of dollars into an LLC. He understands charging orders. And the law in Florida says the only remedy that a creditor of a member, a guy suing the owner, the only remedy is a charging order. So the government puts him in jail and they say, okay, Mr. Olmsted, give us all those tens of millions of dollars back. We're going to give it back to your victims. And he sticks his tongue out at him and says, this is in an LLC. You get a charging order. And by the way, I'm sitting in jail. How often do you think I'm going to declare a profit? Your charging order is worthless. So he told the Supreme Court justices in Florida to go pound sand. There's only one problem with that. There's a lot of sand in Florida. The Supreme Court justices in Florida ain't interested in pounding sand. So they scratched their little noodle and they said, okay, what's the purpose of a charging order? The purpose of a charging order is not to protect you, Mr. Olmsted. It's to protect Lee and Grant. You don't got any Lee and Grant, Mr. Olmsted. Screw you. Henceforth and forever in Florida, you've got to have at least two owners in order to get the charging order protection. We now have about 15 states that say 2 owners, no charging order protection. Got to have 2, not 1, 2. And Utah and Idaho have actually passed laws. The nuts and berries, the fruits on the West Coast, the Ninth Circuit says in bankruptcy, you got to have 2. There are a lot of the eastern states that say 2. Florida says 2.
Got it. Interesting.
But you understand why, right?
Yeah, exactly. You don't want...
Well, because I've got to protect the partners, not just you, Mr. Olmsted. You don't got no partner.
Right. So we're talking in general, we're using the term portfolio, and we talked about ERISA plans and how we don't need to do that with ERISA plans because they're protected from the Employee Retirement Income Security Act, right?
Right, ERISA.
It's a non-starter.
You can't even do that because the 401k is unique to you. Your name, you has to be the owner.
Right. And that's exactly where I was going with it, because IRAs have the same treatment, right?
You've got to be the owner.
Right. So what do you do with IRAs in states that don't? What do you do with IRAs in states that are
if you're in a state that doesn't protect the IRA?
Yeah.
You bend over and you hold your ankle really tight. Your ankles.
Cross your fingers, I guess, huh?
Any other questions?
So you've been speaking on this topic for a long time. We collaborate with our clients' tax preparers and attorneys, and we talk to estate planning attorneys a lot about this kind of stuff. Nobody has once suggested putting the trust inside an LLC. Why is it not more?
No, you're going to put the LLC
discussed
inside of the trust.
Excuse me, the LLC.
You said that backwards, Grant.
Excuse me. The LLC goes inside of the trust, and the portfolio is named in the name of the LLC.
Right.
Yes. Excuse me, I misspoke. Why is nobody else talking about this?
Because, frankly, attorneys don't care whether there's a mess. They make their money by cleaning up the mess.
Aha.
I will not take you as a client. I will educate you.
Interesting. And even asset protection attorneys I've spoken with have not heard this, and I don't have that interaction nearly as frequently.
If you tell them, they will say, yes, that's correct.
Do you think your average estate planning attorney is going to be privy to the nuances of everything that you're talking about here?
No. Your average estate planning attorney doesn't understand LLCs. You've got to marry business and estate planning and asset protection and taxes. There are very few people that marry all of those disciplines.
Right. And we're talking about shielding portfolio assets. I suspect that the exact same would be true for business assets as well.
Business assets, absolutely. Your real estate. In the 2008, 9, 10, I saw people lose 30 pieces of property. If they'd taken this piece of property, put it in one LLC, this piece and put it in another LLC, then when this one went bad, they give it back to the bank. The bank sells it. There's a deficiency. They come back to the owner. The owner declares bankruptcy. Wait a minute. It's in an LLC. It has the corporate shield. You can't come to the owner, right? Yeah, you can. Because I'll guarantee you signed that mortgage personally. I'll bet you $100.
Right.
Straight up. So you signed the mortgage, you're liable. So they come to you. The question is, can they get this second piece of real estate? They come and get the second piece of real estate. They sell it. There's a deficiency. They go to the third. I saw people lose 30 pieces of property doing this. If it's in an LLC, the answer is no. They can't come and get it, even if you declare bankruptcy. All they can do is get the charging order. If I've crossed my T's and dotted my I's, I've got this piece protected. Now, the real estate gurus will run around saying, oh, you need a separate LLC for each one of your pieces of real estate. You can't manage 30 LLCs. I have 12 pieces of property. I have 3 LLCs. How much are you willing to put in one basket? If you try and put 30 eggs in 30 baskets, you can't walk down the street and carry them. You don't want all your eggs in one basket. So how many are you willing to risk at a time? If I have 3 baskets and 30 eggs, I can risk 10 at a time. But if 10 goes down, that doesn't wipe me out. I still got 20 left. So that's a risk analysis on your part. I can't do that.
So you mentioned that Wyoming, I think, was the first state to recognize the LLC, and you use the analogy, the mom and the dad of all this.
Partnership, corporation.
Partnership and corporation. I have heard real estate investors talk about Wyoming being maybe the only state that entertains serial LLCs, and I don't understand what that means. Could you enlighten us on that?
Yeah, people say go to Wyoming. Put your LLC in Wyoming. I'm just going to cut through the chase for you, okay? No, the LLC is in the state where you own property and where you live and where you work. This whole Wyoming, Nevada, Delaware, New Mexico, Utah, it's all a scam, guys. You can't give me a reason. Now, having said that, 2% of the time I'll say, yeah, go put your LLC in Wyoming. But 98% of the time the answer is no. Now, a series LLC is a mommy LLC. You usually pay more for it to set it up at the state. But the mommy LLC can then have baby LLCs. And these baby LLCs, you don't have to file them with the state and pay the additional fee and all of that garbage. So you can have, we call this one the principal LLC, and the baby LLCs we call the cell LLCs. So you can have as many cells as you want. Now, in theory, these each have to have their own bank account and their own formalities. That we got to keep these separate, okay? In Utah, it's a grand total of, I think it's up to like $20 a year to have an LLC, $160 to set one up. Utah has series LLCs. I use separate LLCs. California is the one you wish had series LLCs because it's $850 a year per LLC. But it doesn't not only have series LLCs, it gets California citizens for every LLC they own a piece of in every other state. Welcome to California. But these series LLCs, let me go back a little bit. In 1977, they create the LLC in Wyoming. It's a slow winter. The jackrabbits aren't running. There's nothing to hunt. The Wyoming legislature has nothing else to do. So they create the LLC, which is actually an old European entity. The LTDs in England, the GmbHs in Germany. Volkswagen is a GmbH. Gesellschaft mit beschränkter Haftung. My Deutsch. But it's a company with limited liability. And so they brought it to Wyoming. The first question is, okay, how are we going to tax this? And they wrote the IRS and they said, how are we going to tax it? It takes the IRS 20 years to do anything. 20 years later, 1996, the IRS says, we don't care how you tax it, you choose. So you can tax it any way you want. But you didn't hear about LLCs until at least 1996 and probably 2006. The lawyers get together and they create what are called uniform acts. We have 180 of them: uniform bankruptcy, uniform divorce, uniform trust, uniform corporate, the uniform LLC, the big one came in 2006.
And those may I interrupt for a moment? Those uniform acts are federal framework that the states can then apply. Is that how that works?
No, it's the American lawyers and the estates adopt them. There's no federal aspect to it.
Okay, I see.
But the states adopt these as a model act, okay?
Sure, okay.
and they make little changes. There are little changes here and there. For example, now in Florida, they started out with one member, only recourse that anybody has against the LLC is a charging order. Then they made it two. So they change a little bit. But after we got the 2006 Act, the lawyers said, okay, we know what to do now. And so you started to see LLCs come into existence. Before that, you'd go to the lawyer and he'd say, I don't think you really want an LLC. We don't know enough about it. Let's just do a corporation. And the series LLCs, the mommy LLC with the baby LLCs, they're in the same place that the LLC was prior to 2006. I don't know how another state is going to look at your series LLC. Are they going to honor the baby LLCs? I don't. So there's a lot of things that we don't know yet about the series LLCs. So I don't use them much, even though I'm in Utah and we have series LLCs. About 15, 16, 18 states have series LLCs now.
Interesting.
So, depends on which state. If it's really expensive, I'd try the series trick. If it's not that bad, Illinois, it's quite expensive to set up the mommy and then the babies. If I had three baby LLCs, I'd probably just get three regular LLCs. They're cheaper than the mommy LLC a little bit, $100 or something. But, I don't know. We don't really know how we keep them all separate. We don't know about tax return. There's a lot of questions. So that's kind of my take on the series at this point, Grant.
Sure. That's helpful. Now, a lot of our listeners are probably out there, maybe slightly confused, but really interested in what you have to say with regard to asset protection using an LLC. And they're thinking, hey, why don't I just pop over to LegalZoom and fire one of these things off in the next 15 minutes? Probably not a good idea, I would suspect, right?
Well, you can get your LLC from LegalZoom. It's perfectly legal. They actually do a pretty good job. The problem is they're pitching to the lowest common denominator. You're probably not the lowest common denominator. So you probably want a little more. Their operating agreement, their bylaws, you call them operating agreements in the LLCs, their operating agreement is 5 pages. I figured you need 20 to 40 pages to really address the issues that commonly come up in an LLC. So is their LLC legal? Absolutely. I had a California businessman call me, it's been 15 years ago now. And he ran a big ad agency in LA. They had it had been a partnership for years. We're talking 150 people type company. And his partner said, we really need to do something. So they went to LegalZoom and they got the LLC. And about 6 months later, they got sued. And it took about 15 minutes in court for the people suing them to make the argument, hey, Your Honor, this isn't the real deal. We don't have to honor this LLC. We can sue these guys personally. And the judge says, yeah, you can. Took them 15 minutes on that argument. They'd set up the LLC. They had an LLC, but they didn't do what was required to make the LLC work. And that's what the internet sites, even the lawyers, never teach you how to do. Even if they'd been to a lawyer in California, chances are the lawyer would have given them an LLC, given them the operating agreement, kissed them on the cheek, and said goodbye. It's the other cheeks, okay, Grant?
Yeah, okay. Hey, you mentioned bending over earlier. I'm just trying to follow along.
You did hear about the lawyer who had a farmer for a client, and he needs a signature. So he goes out to the farm, and sure enough, this farmer is in the middle of the cow pasture. It's early morning. The steamy's coming up off the grass, So the lawyer hops the fence in his 3-piece suit. He's trucking across the cow pasture, and he steps in this big pile. I mean, it's warm. It's still steaming. And he looks down at his leg up to his ankle in this big pile. And he says, "Oh my gosh, I'm melting." That's the punchline, Grant. You can laugh now.
Lawyers always have the best lawyer jokes. It never fails. You guys must hear them all the time.
Half of them hate them and half of them love them.
So what kind of stuff what kind of stuff should you be doing to work within your own operating agreement? You have to understand what the operating agreement is. What kind of maintenance does an LLC need?
You got to understand what you need to do. The mistake that this ad agency made is they needed to notify all of their clients that they were now operating as an LLC. These people have been dealing with a partnership for 20 years. They had the right to continue to deal with a partnership until they were notified, hey, we're no longer a partnership, we're now an LLC. And so that was the argument. So you've got to understand the nuances. Can I give something to your peoples? I don't know, Grant. I didn't ask you.
Yeah, please do.
I have a 20-page write-up on LLCs called the LLC mini course. And I'd be happy to give that to your folks, no charge. So I'll give you the link and you can put it in the notes or wherever you put it. It's going to be easy. It's just LegaLees, LegalEes. It's a pun on my name, Legal Lee, but there's only one L in the middle. LegaLees.com/Grant. That's an easy one.
Perfect. I appreciate that. What for people who want to learn more about you and hear about your speaking, where else can we direct people?
Just the LegaLees website. I post on there where I'm going to be and all over the nation.
Perfect.
Last one was in Tampa. The next one's actually in Cocoa Beach, Florida. And I've got them in, Nashville, Boston, Virginia Beach. I got a bunch of them coming up this year, so.
Wonderful. Well, Lee, I really enjoyed this conversation. I've always wondered about the genesis of LLCs in the first place, and I learned a whole lot, and I'm really confident that our listeners did here. And I just want to thank you for your time. This has been wonderful.
Well, I hope it helps people. If you can avoid the problem, you've got to do it now. You can't do it. If you can see the problem coming, it's too late. We have fraudulent transfer, fraudulent conveyance statutes and everything, and we bring everything back. So you have to do it now. But that's how I would protect a larger portfolio, the LLC owned by the living trust.
Excellent. Well, we will run with that, and I'm sure some people will be visiting the site. We'll post all that in the show notes so people can navigate to it.
Okay, great. Thank you, Grant. We'll have to come back and talk taxes someday. They're fun.
I'd love to. I love talking taxes, which is pretty weird, but here we are.
Yeah.
Until next time, Lee.
Big part of our life.
Yeah, that's right. That and death, I guess, right?
All right. We'll catch you in a while, Grant. Thank you.
Thanks for tuning in to Grow Money Business, the podcast dedicated to helping business owners optimize income, pay less in tax, and invest prudently. Be sure to subscribe to the podcast on iTunes, Google, Spotify, or wherever you digest podcasts to ensure you don't miss out on future episodes and announcements, and feel free to submit questions to growmoneybusiness.com.